People,
it is happening.
Groups are actually starting to sue YouTube.
Ow.
It's God punishing me for Schadenfreude. Viva Frei, Montreal litigator turned YouTuber. I do these things called vlogs on YouTube. Most of you know what they are already, but blah, blah, blah. Law-based vlogs. VLA vlogs. I have jokingly made videos suggesting that I might sue YouTube. One of the videos I suggested that I might sue YouTube on the basis of defamation because they removed one of my videos from YouTube on the basis of violating the terms of service as relates to hate speech. That video was not only unremoved or returned to the platform, but it was actually remonetized after I presume an actual human being with an actual functioning brain watched the video and determined not only was there nothing that violated the terms of service as relates to hate speech, but that the video was perfectly monetizable in its content because it was just a legal analysis of... I'm not even gonna get into it. In another more recent video from a few days ago, I was jokingly suggesting that I would sue YouTube because they had, unbeknownst to me, demonetized close to a dozen videos that had been previously monetized for an extended period of time. That being relevant to the extent that I don't go back to periodically check that videos which have been monetized for over 2 months do not get suddenly and without any notice whatsoever demonetized, thus punishing the content creator who thinks that a video that has been monetized is still monetized when YouTube has for no reason whatsoever demonetized it. And in that video, I started noticing a bunch of comments saying, check out PragerU's lawsuit against YouTube, because they are in fact suing YouTube, if not on the exact same basis that you were alluding to in your previous videos, you being me and my previous videos being those other videos. If not on those bases, they are nonetheless in fact suing YouTube, and one of the bases on which they are suing YouTube is First Amendment violations for freedom of speech and discrimination under the law. Now, when I say that this is not Schadenfreude, that is to say the German word for taking pleasure in the suffering of others, I'm not saying that just to say that. I am not happy that YouTube is getting sued in the sense that I'm happy that someone is getting sued. I am, call it optimistic, that the checks and balances of the legal system will compel YouTube to behave in an appropriate manner as relates to its 1 billion users and however many hundreds of millions content creators, that it'll just result in YouTube being compelled to treat people properly and equally on the platform that they've created, which is supposed to be a platform of freedom of speech, free expression of ideas, and, you know, all things good and nice and rosy and whatever. So PragerU is suing YouTube. I got a copy of the proceedings and I said I have to do a vlog on this. In preparing for this vlog, I have realized that it is a tremendously complicated issue, but not complicated because of the allegations in the lawsuit. It's a complicated lawsuit because of the nature of the law, federal versus state level courts, federal law versus state law, and, you know, law in general, which is confusing even to trained lawyers, and it can therefore be somewhat, what is the word for unclear to people who are not trained in the legal interpretation of the code that is the law. PragerU, for those of you who don't know, is a Section 5013C, which is a very flavin... it's a very flavin way of saying that they are a not-for-profit organization. They are suing YouTube and Google. And for those of you who don't know this, Google owns YouTube. Google is YouTube's parent company. Google itself is owned by a conglomerate parent company called Alphabet. So you have Alphabet, the big umbrella company, owning Google, Google owning YouTube. Basically, Alphabet owns all of it, but Google owns YouTube for the purposes of this lawsuit. Google is not a not-for-profit corporation. Google is a for-profit corporation. Google, for those of you who don't know this, is the largest search engine on the worldwide interwebs. YouTube, for those of you who don't know this, is the biggest video hosting platform on the worldwide interwebs. So you have the biggest search engine owning the biggest video hosting platform, and this could potentially lead to some conceptual problems, which we don't need to get into for the purposes of this vlog, but go ahead and in the comment section hypothesize. Use your imagination.
What could conceivably happen
when the largest search engine owns the largest video hosting platform and can create algorithms which dictate or influence the information you get when using either of those platforms? Just use your imagination. So PragerU is suing YouTube and Google for 7 headers of damages, 2 of which fall under federal law, 5 of which fall under state California law, but we'll get into that. PragerU is described as a right-of-center conservative YouTube channel that creates educational videos on any number of subjects. What they noticed was happening a lot was that their videos were being systematically demonetized or placed in restricted mode on YouTube. When a video is demonetized, it is not eligible for AdSense revenue, or it is in fact eligible, but for such a discounted amount of the AdSense revenue because apparently only certain companies will pay a certain amount to advertise on videos that are deemed to be not suitable for advertisers. But it's not just a question of being deprived revenue for your hard work that PragerU is complaining about. PragerU is also saying that their videos are being placed in restricted mode. So not only are these videos demonetized, by being placed in restricted mode, these videos simply will not have the reach to reach people because they will not be put in front of the eyes of people who might otherwise be interested in these videos. They will not be shown to people below a certain age, and they will simply not be promoted to the otherwise 1 billion people who use the service. So PragerU sued YouTube and Google in a federal court in 2017. The motion was dismissed on a motion for summary judgment on a question of law. And flashback to the earlier part of this video where I mentioned that the claim brought by PragerU against YouTube and Google had 7 headers of damages, 2 of which were under federal law, and those 2 claims under federal law were violation of First Amendment free speech rights. The second of which was unfair advertising and unfair competition under the Lanham Act. And those 5 claims under California state law also include freedom of speech, discrimination under the UNRRA Act, we'll get into it, unfair, unlawful, and fraudulent business practices, somewhat reminiscent of what I was complaining about in my other video about the spontaneous demonetizing of videos that were previously monetized, and breach of contract. I think I only named 4 of the 5 state claims, but whatever. 5 claims under state law, 2 claims under federal law. And what did the federal court rule? The federal court ruled that Google and YouTube were not government entities. And as such, First Amendment claims cannot be brought against private citizens or private entities. First Amendment claims can only be made against the government. But the federal court did not rule on the 5 other state claims. In fact, what the federal court ruled was that there's going to be a dismissal without prejudice, meaning you can refile your claim at the state level under the state claims and let the state courts adjudicate on state law. If you were to read Google's assessment of the judgment, you'd think that the case was over fait accompli. In fact, their assessment reads as follows. PragerU's videos weren't excluded from restricted mode because of politics or ideology. A federal court has already held that PragerU's allegations are meritless, and we believe the state court will reach the same conclusion. This is an oversimplification to the point of inaccuracy. Apparently, the federal court did not rule or adjudicate on any of the 5 state claims. The court ruled that the state claims ought to be adjudicated by the state courts. But on a federal level, the 2 claims under federal law simply don't apply to Google or YouTube because they are private companies and not government agents, government actors, or government parties. Okay, what now? First of all, PragerU appealed the dismissal of the statement of claim as relates to the 2 federal claims. And that is actually going to oral arguments next week, and we'll have an update on the outcome of that when the 9th Circuit Court of Appeal rules. What else did PragerU do? They filed their claim at the state level. They filed their claim before the California courts under the 5 state claims that they had under their federal lawsuit, but they filed it at the state level. And so in a way, PragerU now has like 2 kicks at the can, so to speak. They can lose the federal lawsuit on the merits if the Court of Appeal affirms the federal court's initial ruling that Google is a private company and as such is not subject to First Amendment claims. PragerU can still lose that lawsuit and nonetheless have a second kick at the can or an actual lawsuit on the 5 other state level claims that they are currently bringing before the state California court. And we will touch on some of those state claims that they are currently bringing before the California state court, but first I want to talk about something that is very interesting at the federal level, and that is the very judgment that Google and YouTube cannot be subject to First Amendment claims because they're private companies and not the government. It had me asking myself, can a private entity, a private individual, a private corporation ever be treated as a government entity for the purpose of First Amendment claims? Now, bear in mind, big caveat, I am a Quebec lawyer, so this is a steep learning curve for me, and in fact, don't treat me as any sort of expert on the subject. I'm just asking the questions that I have as a Quebec lawyer, not knowing the ins and outs and the details and the nuances of American law and American jurisprudence. I was asking myself, how and when can a private entity, corporation, individual ever be treated as a government entity for the purpose of First Amendment claims? And it turns out that there are 4 conditions to determine whether or not an entity can be treated as a government entity for the purpose of First Amendment claims. The first of which is the entity the government? Easy enough. The second of which is it a government agent or a government contractor? Because if it is, it can be subjected to First Amendment claims. And the third and fourth ones get a little more tricky to understand and a little more nuanced. The third condition is one of entanglement. Is the private entity so fundamentally intertwined or entangled with the government that they can no longer be treated in a separate manner from the government? And the classic example would be institutions that receive so much in government grants, so much government funding, that they can't turn around and say, well, we can discriminate because we are a private organization and therefore we are not susceptible to First Amendment claims. If you receive enough government grants, if you receive enough subsidies from the government, at some point in time, you can be sufficiently entangled with the government that you can then become the object of federal First Amendment claims. Who's here? You said you left the house. You know this is embarrassing for me.
Sorry to interrupt.
All right. Now I have to refocus.
Bye.
See you soon. Make some money. I don't know if my video is going to get demonetized. The third one is entanglement, and the fourth is whether or not the company is in fact acting like the government. And what does it mean if a private entity is effectively acting like a government? I mean, the concept would be like it's a private entity that has amassed such a massive amount of real estate that it is effectively acting like the government. I am by no means familiar with the nuanced case law on all of this, but apparently there is case law to the effect that if a private entity gets so big, amasses so much control, gains such an effective monopoly, for lack of a better word, and they begin to act like the government, they can then be subject to First Amendment claims and other federal laws that might otherwise only apply to the government or government agents. So those are the four conditions under which Google and YouTube could potentially be treated as a government actor for the purposes of First Amendment claims. And these arguments are going to be brought before the Ninth Circuit Court of Appeals next week, and we will see if this initial federal court ruling will be upheld or overturned, but that's only at the federal law level. Because PragerU has filed a claim at the state level, they have taken their 5 state level claims that were previously in the federal lawsuit, and they have brought them before the state courts of the state of California. And to many, those state claims are even stronger and going to be easier to evidence than the federal claims, because they do not require Google and YouTube to be treated ostensibly as a government agent. The claims that are being brought at the state level apply to private companies and private individuals, so it's not even like PragerU has to make the argument that Google and YouTube are government agents or government actors that are governed by federal laws. They can take for granted that they are private enterprises governed by state laws which apply to state actors. And what are those laws? I'm starting to sweat here a little bit. Unfair, unlawful, fraudulent business practices is not a particularly complex legal concept. It's just going to be very evidentiary based. PragerU is just going to have to show that YouTube and Google engaged in some unfair or fraudulent business practice. And apparently from the statement of claim, the one that was dismissed at the federal level, which was, basically reinserted into the state level claim, they make allegations to the effect that all of their videos systematically and without any rhyme or reason get demonetized and placed in restricted mode, thus being restricted in terms of who will see them on the platform for no better reason. And when the same videos are uploaded by other users, they are not systematically restricted or flagged. So therefore PragerU is being subject to some form of unfair or fraudulent practice by YouTube and Google. Breach of contract is also another claim that is easy to conceptualize, but is going to be heavily fact dependent. And what would this breach of contract look like? I mean, YouTube has terms of service that presumably allow them to do whatever they want, but that doesn't mean that they can in fact do whatever they want. Also, if YouTube promotes itself and puts itself out there as a free speech platform, one where people can freely express their ideas without fear of reprisal or being relegated to the restricted and demonetized mode for no better reason, that can be a breach of contract. YouTube promotes itself as a platform for freedom of expression and free speech. If it acts in a way that is contradicting its stated purpose, that can be sanctionable. But the claim at the state level that I found particularly interesting, primarily because I had never heard of it, was discrimination under the UNRRA Act. The UNRRA Act, U-N-R-U-H, is a 1959 piece of legislation that outlaws discrimination on a number of bases: race, religion, sexual orientation, ancestry, nationality, disability, and this applies to private actors, not to government actors. And for those of you who are wondering where the UNRRA Act got its name, it was named after Jesse M. Unruh, also known as Big Daddy Unruh. And the text of the act reads as follows: all persons within the jurisdiction of the state are free and equal, and no matter what their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, or sexual orientation, are entitled to the full and equal accommodations, advantages, facilities, privileges, or services in all business establishments of every kind whatsoever. Pretty broad, pretty clear, and pretty succinct. PragerU is arguing that Google and YouTube, which have their headquarters in California, which under the terms of service choose California as the proper jurisdiction for any and all claims. Any business operating in California cannot discriminate on any number of bases. PragerU is arguing that what Google and YouTube are doing is political discrimination against PragerU because of the political nature of the content they are promoting and not because of any objectionable content in and of itself. I am planning on getting a live stream Q&A, or at the very least an interview with the attorneys representing PragerU. We'll see if it happens, but we're going to let the oral arguments next week go by, because anybody who has ever been a lawyer, worked with a lawyer, seen a lawyer knows that they are worked over their heads all the time, especially the week before perhaps the biggest hearing of their lives. So that's on the to-do list, and we are certainly going to follow this up as there are any developments, because the counsel for PragerU basically said that this is possibly the most important lawsuit in the history of humanity. Maybe a bit of an exaggeration, but not that much, because freedom of expression, freedom of information, access to information is possibly the most important thing in the world. And when you have the biggest search engine, who owns the biggest video hosting platform, effectively dictating what people can see, manipulating what they can see, penalizing and demonetizing those, not for actual content issues, but potentially for political, ideological issues, Houston, we might have a problem. Now, all that to say, if you like this video and you like my content, be sure to like, share, subscribe, hit the notification bell. If you want to support the channel, be sure to pick up one of these Vlog Dog shirts. The link is going to be somewhere. There's a PayPal donation link somewhere in the banner of this channel thing. You can become a member if you don't have any moral qualms giving some money to YouTube in order to support the channel. But I like the shirts because at least you get something in exchange for something, and you can wear it. If you do get one, take a picture of it, post it on social media, tag me. I love seeing people actually wearing the shirts, and now you know your vlog. Peace out. Boom!